In a move that sent immediate shockwaves through the American legal and political landscape, President Trump, mere hours after reassuming office in January 2025, signed a provocative executive order. This directive aimed squarely at ending birthright citizenship for children born in the United States to undocumented immigrants or individuals present on temporary visas. The administration framed this as a crucial measure to uphold the integrity of U.S. citizenship and control immigration. However, critics swiftly decried it as a fundamental misreading of constitutional law and a direct challenge to a cornerstone of American identity, setting the stage for an intense and far-reaching legal confrontation that would quickly escalate to the highest court in the land. At the heart of this contentious debate lies the Citizenship Clause of the 14th Amendment to the U.S. Constitution. Ratified in 1868 in the aftermath of the Civil War, this vital clause unequivocally states, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside." For over a century, the overwhelming legal consensus, supported by historical precedent and Supreme Court interpretations, has understood this language to guarantee citizenship to nearly everyone born on U.S. soil. This principle was foundational, intended to ensure that the rights of citizenship were extended broadly, particularly to formerly enslaved persons and their descendants. President Trump's executive order hinges on a specific and historically minority interpretation of the phrase "subject to the jurisdiction thereof." The administration argues that this phrase inherently excludes the children of parents who are not U.S. citizens or lawful permanent residents, particularly those who are undocumented or in the country on temporary visas. Their rationale suggests that such parents owe primary allegiance to a foreign power, and thus their children are not fully under U.S. jurisdiction at birth for citizenship purposes. This interpretation directly challenges the long-standing understanding that jurisdiction refers to being subject to U.S. laws, a condition met by virtually all individuals physically present in the country. The issuance of the executive order immediately ignited a firestorm of opposition from civil rights groups, immigration advocates, numerous legal scholars, and a significant portion of the political spectrum. Many viewed the president's action as an unconstitutional attempt to legislate via executive fiat, bypassing Congress on a matter of profound national importance. The order was not merely seen as a policy shift, but as an assault on the established legal framework of American citizenship. Concerns were vociferously raised about the potential creation of a stateless underclass, and the moral implications of denying citizenship to individuals born and raised within the nation's borders, prompting pledges of robust legal challenges. The legal response to President Trump's executive order was both swift and forceful. A broad coalition of plaintiffs, including 22 U.S. states, the District of Columbia, several prominent immigrant rights organizations, and, most compellingly, 4 pregnant women whose unborn children's citizenship status was cast into doubt, filed lawsuits across the country. These legal actions uniformly argued that the executive order represented a clear violation of the 14th Amendment's guarantee of birthright citizenship and constituted a significant overreach of presidential authority. They sought immediate judicial relief to prevent the order from taking effect and causing what they described as irreparable harm to countless individuals and families. Responding to these urgent pleas, federal judges in 3 separate districts, Maryland, Massachusetts, and Washington, took the significant step of issuing nationwide injunctions. These powerful judicial orders effectively halted the implementation of Trump's birthright citizenship policy across the entire United States. The judges, in their respective rulings, found that the plaintiffs had demonstrated a strong likelihood of success on the merits of their constitutional arguments. They also determined that allowing the executive order to proceed would inflict serious and irreversible damage, not only to the individuals directly affected, but also to the fabric of constitutional law and societal stability. The Trump administration strongly contested these nationwide injunctions, arguing that the federal district courts had grossly exceeded their legitimate authority. The Justice Department contended that such sweeping injunctions, which block a federal policy across the entire nation, based on a ruling by a single judge, were an improper exercise of judicial power. According to the administration's legal team, any injunctive relief should be narrowly tailored, applying only to the specific plaintiffs involved in the particular lawsuit, or at most, to the plaintiff states. They asserted that these broad prohibitions amounted to judicial overreach, allowing individual judges to dictate national policy. This battle over nationwide injunctions became a recurring theme and a significant source of frustration for the Trump administration. According to the Justice Department, nearly 40 different court injunctions had been filed against various Trump administration orders since the commencement of his second term. In a March 2025 court filing, the government lamented that universal injunctions have reached epidemic proportions. A Justice Department official further articulated the administration's view, stating to reporters that such court injunctions fundamentally thwart President Trump's policy agenda and are perceived as a direct attack on the presidency itself, hindering its ability to govern effectively. The escalating conflict over the president's executive order and the judiciary's power to block it inevitably found its way to the United States Supreme Court. The court announced it would hear arguments on Thursday, May 20, 2025 in the case of. Significantly, the primary question before the 9 justices was not the direct constitutionality of President Trump's attempt to redefine birthright citizenship. Instead, the case centered on the procedural but critically important issue of whether lower federal court judges possess the authority to issue nationwide injunctions that can halt a presidential order across the entire country, a practice that had become a frequent check on executive actions. The Trump administration's lawyers passionately argued before the Supreme Court that these nationwide injunctions were an unconstitutional encroachment on executive power. They contended that allowing a single district judge to issue an order that binds the federal government across all states and territories effectively permits government by judiciary, subverting the president's authority to implement policies and enforce laws. The administration sought a ruling that would significantly curtail this judicial tool, thereby allowing executive orders to take effect more broadly and rapidly, even while underlying legal challenges might continue to wind their way through the court system, potentially in a more geographically limited fashion. Conversely, those defending the use of nationwide injunctions, including numerous states and civil liberties groups, painted a starkly different picture. Ilora Mukherjee, a clinical law professor, emphasized the potential for widespread chaos and legal uncertainty if such injunctions were to be restricted. She argued that without the ability to issue nationwide relief in appropriate cases, federal laws could be applied inconsistently across the country, creating a confusing patchwork of rights and obligations. New Jersey Solicitor General Jeremy Feigenbaum echoed these concerns, highlighting the immense administrative burdens that states would face in trying to navigate differing legal regimes, particularly on an issue as fundamental as citizenship. The Supreme Court, with its current conservative majority that includes 3 justices appointed by President Trump during his first term, listened intently to these arguments. The implications of their eventual ruling are profound. A decision siding with the Trump administration on the scope of injunctions could dramatically reshape the balance of power between the executive and judicial branches, potentially making it much harder for courts to provide immediate, broad-based checks on presidential actions. As of the hearing date, there was no clear indication of when the court might issue its opinion, leaving the fate of nationwide injunctions, and indirectly the birthright citizenship order, hanging in the balance. The legal and constitutional wrangling over birthright citizenship and judicial power carries profound human consequences. Should President Trump's executive order ultimately be allowed to take effect, either through a favorable Supreme Court ruling on injunctions or a later decision on the merits, tens of thousands of children born each year in the United States could be denied American citizenship from birth. Plaintiffs in one of the lawsuits argued that such a policy would effectively impose second-class status on a significant population, creating a generation of individuals born and raised in the U.S. yet stripped of the fundamental rights, protections, and opportunities that citizenship affords. Immigration law experts like Alex Kuick, a professor and attorney, have warned of even graver outcomes, including the possibility that these children could be rendered undocumented, or in the most extreme cases, stateless. If the United States denies them citizenship and their parents' home countries also refuse to recognize them as citizens, a distinct possibility given varying international laws and the circumstances of their parents' departure, these individuals would exist in a legal limbo. This raises complex and distressing questions about where the U.S. government could deport them, if anywhere, and what their status would be under international law, potentially leading to significant humanitarian challenges. Furthermore, a Supreme Court decision that limits or eliminates nationwide injunctions could usher in an era of fragmented federal law enforcement. If the birthright citizenship order or other federal policies could only be blocked in specific plaintiff states or districts, the United States could see a return to a patchwork system where fundamental rights and legal statuses vary dramatically depending on geographical location. Some commentators have drawn parallels to the chaotic period before the Civil War, such as the Dred Scott era, where citizenship was inconsistently applied, leading to profound legal and social instability. States would face enormous administrative and logistical hurdles in verifying citizenship and managing benefits under such a system. Ultimately, the battle over President Trump's birthright citizenship order and the Supreme Court's examination of nationwide injunctions touches upon the very foundations of American governance. A ruling in favor of the Trump administration's position on injunctions could significantly enhance the power of the presidency, allowing for more rapid and sweeping implementation of executive orders with fewer immediate judicial checks. This case is a critical juncture in the ongoing national conversation about immigration, the enduring interpretation of the Constitution, particularly the 14th Amendment, and the delicate balance of powers that defines the American Republic, with implications that will resonate for generations.